Hello and welcome to BYJU'S IAS. Welcome to yet another episode of Explained. The topic of this week, the law of sedition in India and freedom of expression. First up, two news channels in Andhra Pradesh. They aired the interview of an MP belonging to the YSR Congress. YSR Congress is the ruling party in Andhra Pradesh. But this MP is a rebel. He criticized his own government's handling of the COVID situation. Result? Sedition case was filed against the two news channels for airing this interview. What about the MP? Same treatment, booked under sedition. But to be factually correct here, this MP was booked under sedition not only for criticizing his own government's handling of the COVID, but also because of his alleged inflammatory speeches towards a particular caste group, a community in Andhra Pradesh. When the matter reached the Supreme Court said something spectacular. Supreme Court said it is time that we define the limits of sedition. Case number one. Case number two, veteran journalist Vinod Dua. He uploaded a video on his YouTube channel last year. The lockdown had just been imposed. Lakhs and lakhs of workers started migrating from cities back to their villages. Vinod Dua, as a journalist, he expressed concern and he criticized the government's handling of the situation. He particularly expressed concern regarding the food, shelter for these migrants. He expressed concern that if the government is unable to deal with the situation, there may be riots for food. An individual in Himachal Pradesh filed a case of sedition against journalist Vinod Dua. Why? He complained that since Vinod Dua is talking about riots for food, which basically means he is inciting people to violence, which comes under sedition, and that is why sedition case was filed against him and FIR was filed. Vinod Dua approached the Supreme Court, and last week Supreme Court quashed this FIR and Supreme Court said no, this is not the fit case for sedition. Supreme Court said something else as well. Supreme Court said citizens have the right to criticize the government. Citizens have the right to comment upon the measures undertaken by the government functionaries. And this criticism, this commentary cannot be sedition. Supreme Court said something else. Supreme Court said every journalist, not every individual, every journalist, specifically a journalist, is entitled to protection under Kedar Nath judgment. And what is this Kedar Nath judgment? We'll come to this in a moment. This was case number two. Case number three, today, a filmmaker in Lakshadweep, booked under sedition. Why? She was participating in a TV debate and she made two allegations. Number one, she criticized the administrator of the Union Territory, Lakshadweep. She criticized the manner in which the administrator has handled the COVID situation. She says that there were strict quarantine norms which were violated and softened by the administrator. That is why previously there was no case of COVID-19 in Lakshadweep and now there is a spike. Criticism, number one. Number two, she said and alleged that the center has launched a bio war against the citizens in Lakshadweep. For this, a case of sedition was filed against this lawmaker. But be that as it may, in this today's session, let's look at all that you need to know regarding sedition. But how? What all are we going to cover in this lecture? We will look at what is sedition, what constitutes sedition, what is the origin of this law. We will look at the misuse of this law in pre-independent India. We will look at two very high-profile cases, one of Lokmanya Tilak and the other of the Mahatma. We will look at various Supreme Court judgments after the independence, and we will also be looking at and we will be addressing questions, should sedition law continue or should it be scrapped? So stay with me and let me take you on a fascinating journey. And before that, if you're liking these initiatives, press the like button, subscribe to our channel if you haven't yet, and share the links of these classes with your friends and fellow aspirants. Let's get started and look at Section 124 capital A of Indian Penal Code. What is it? If you say something, if you write something, if you draw something, maybe a cartoon, and because of which You are promoting disaffection against the government established by law. You are promoting hatred, or you are bringing into contempt the government established by law. You are guilty of sedition. And what is the punishment? Life imprisonment or 3 years imprisonment, to which fine may also be added. But there are two things here. If you are promoting disaffection, not against the nation, nation is a permanent entity. If you are promoting disaffection against the government established by law, this is sedition. So not nation, government established by law. That's number one. Number two, if you are not promoting disaffection, but you are attempting it. If you attempt to promote disaffection, if you attempt to promote hatred or contempt against the government established by law, this is sedition, for which you will be punished. But what is the origin of this law? Thomas Macaulay, an Englishman, he studied law at the Cambridge, but he never really practiced it. Then he ventured into politics, he ventured into writing. He was elected twice to the House of Commons as well, but he was not financially secure. Then what happened? 34-year-old Thomas Macaulay, he was sent to India. £10,000 a year. Be part of Governor General's Council and be part of the first Law Commission and draft the Penal Code for India. And we still use the same penal code designed by Lord Macaulay. Lord Macaulay, when he started working on this draft, he talked about one section. He said, if you excite disaffection against the government of East India Company, because at that time it was East India Company, if you are exciting disaffection against the government of the East India Company, we will punish you. And what is the punishment? Banishment for life. Life imprisonment. Fine may also be added. This was only a draft. And this draft was completed in the year 1837. 2 decades later, 1857, a massive revolt broke out in the northern and central part of India, which nearly swept away the British rule. Revolt of 1857, the mutiny of 1857, or what we call the first war of India's independence. This revolt of 1857, it acted as a catalyst. Catalyst in the sense that now let's quickly implement this Indian Penal Code. And this Indian Penal Code was enacted in the year 1860, 1 year after the death of Thomas Macaulay. Macaulay died in 1859. But Indian Penal Code was enacted in 1860. But incidentally, this section, exciting disaffection against the government established by law, this section, which was part of the draft, drafted by Macaulay, it was not part of the Indian Penal Code. Now, there are various theories why. There's a beautiful book written by lawyer and activist Abhinav Chandrachud. He says that there are different reasons why this sedition, as we call it today, this was not part of Indian Penal Code in 1860. Some people say it was a mistake. By mistake, this section was not part of Indian Penal Code in 1860. So by mistake, it was not added. But this mistake was rectified 10 years later in 1870, when sedition was included in the Indian Penal Code. That explains this word, this letter, capital A, which means it was an amendment. It was added to the Indian Penal Code, was not originally part of the Indian Penal Code, added to the Penal Code in 1870. And some people write that this was in response to the Wahhabi movement. The Wahhabi movement, the leaders, some people say they would travel from villages to villages. They would incite disaffection against the government established by law. They would tell the Muslim community that it is your religious duty to wage jihad against the British government. We need to understand that we were a colony. We were ruled by an alien government, by a foreign government. And to overthrow this foreign government, we needed to educate the masses. We needed to tell the people that this is not your government, this is an alien government. So overthrow this alien government so that we can govern ourselves, so that we can make laws for the betterment of the people of this country, so that we can make laws for ourselves. So to overthrow this foreign government, we needed to educate the people. We needed to carry on the propaganda. And British said, we can't allow this propaganda. So if you are carrying on this propaganda, you are promoting disaffection against the government established by law. This would be sedition and you will be booked for it. You will be sent to life imprisonment. And that is how in 1870, sedition was incorporated in the Indian Penal Code, and from there onwards, the sedition continued to be used in India. So long story short, sedition was primarily used to curb the nationalist feelings from getting developed, to curb the nationalist movement for freedom in India. And it was used, overused, misused, and abused in the colonial period. Let's look at the two high-profile cases of misuse. One of Lokmanya Tilak and the other of the Mahatma. First up, let's look at Lokmanya Tilak. Bal Ganghadhar Tilak was a fairy leader and he was booked under sedition twice. The first trial for sedition, it has its origin in the famine of 1896. It's very hard to understand that between 1876 and 1900, hundreds of famine took place in India. 1,90,00,000 people lost their lives. Bal Ganghadhar Tilak also started a weekly newspaper named Kesari, and he criticized the British government during this famine. Why? Because despite the fact that people were under crisis, the British government insisted on collecting land revenue. Bal Ganghadhar Tilak wrote articles in this weekly newspaper, criticized the government, and then 1897, bubonic plague struck Pune. And that is how Epidemic Diseases Act was enacted in the year 1897, which is in force even today. So during COVID-19 pandemic, you would come across this law, Epidemic Diseases Act 1897. It was passed because of the bubonic plague in Pune. And then the government, the British government, what they decided to appoint Walter Charles Rand as a plague commissioner, somebody who would be responsible in ensuring that this plague does not spread. And then repressive measures were undertaken by the British government. The officers would barge into the homes of the people, would strip the people naked, including women. And it reached to a point where even the religious places were desecrated. Bal Ganghadhar Tilak, he's a journalist, he's writing articles in Kesari, and in one of the articles, he is justifying the killing of Afzal Khan by Shivaji. Look at this carefully. In his articles, he is justifying the killing of Afzal Khan by Shivaji, and on the other hand, Shapekar brothers killed Rand because of his repressive measures. The British press quickly draw the equivalence. The British press criticized the British government for not taking action against Tilak. They said, book Tilak for sedition because he's inciting people to violence. Tilak was booked for sedition, and his lawyer was Dinshaw Dawar. Interesting figure, and I'll tell you how. Dinshaw Dawar applied for bail for Bal Ganghadhar Tilak, but this bail was not granted. And then the trial started in front of Justice Arthur Strachey. And this was a farce right from the beginning. But Lokmanya Tilak pleads not guilty. He says, no, my lord, I'm not guilty. I'm not promoting disaffection against the government established by law. The judge said, you may be right. You are not promoting disaffection against the government established by law, but in your eyes, there is absence of affection. Since there is absence of affection, which means you are promoting disaffection against the government established by law, 18 months in jail, Mr. Bal Ganghadhar Tilak, and he was convicted for sedition. This despite the fact that Bal Ganghadhar Tilak then was the member of the Bombay Legislative Council. So this was the first trial of Bal Ganghadhar Tilak when he was booked and charged for sedition. Then came the trial number 2. Bengal was partitioned. The year was 1905. The British government said it is primarily because of administrative convenience. This Bengal is a huge area. We are not in a position to govern this. So for effectively governing such a vast area such as Bengal, we need to break it, divide it. And that's how partition of Bengal took place. That was the official reason. Although the real reason was to drive a wedge between the Hindus and Muslims. And this was the time when The capital of India was also shifted from Calcutta to New Delhi or Delhi. Lokmanya Tilak, what he did, he also started writing articles. Again, something else happened. A bomb was hurled, and this bomb was hurled by Khudiram Bose. But accidentally, it killed 2 English women. And quickly the press said that Tilak is responsible for this. Why? Because Tilak was writing articles in his newspaper, in his weekly newspaper, justifying the violence as well, according to the British. Tilak was arrested, booked under sedition, and he was asked, "Are you guilty?" Tilak again said, "No, I'm not guilty. I'm pleading innocence. I am not guilty of sedition because I'm not promoting disaffection against the government established by law." But Tilak's house was searched. Nothing was found except there was a card on which names of 2 books on explosives was written. And quickly a link was drawn. Here is a card on which, Mr. Tilak, you have written the names of 2 books on explosives. And on the other hand, Khudiram Bose hurled bomb. So there is a link. You are inciting people to violence. You are guilty of sedition. Tilak said there is repression all around. And the only way out for this is self-rule. That's what he called Swaraj. He said, Swaraj is my birthright and we must have it. He was talking about self-rule, home rule, as Annie Besant called it. But ultimately, what the court said, no, you're guilty of sedition. Dinsha Dawar, the lawyer of Bal Ganghadhar Tilak, is now a judge. 1897, he was the lawyer for Bal Ganghadhar Tilak, who applied for bail for Tilak. And now 10 years later, he is a judge. And now he has to try Bal Ganghadhar Tilak. And the judge is saying, Mr. Tilak, your journalism is a curse for India. Booked for sedition, tried for sedition, convicted for sedition, and sent to 6 years in jail in Mandalay. And he only returned in 1914. So this was trial number 2 of Bal Ganghadhar Tilak. And then came the Mahatma Gandhi. Non-cooperation movement, Khilafat movement was at its peak, but then there was violence as well, particularly at Chauri Chaura. Chauri Chaura will not go too deep into the details. 22 policemen were killed, hacked into death, thrown into the fire when the mob rampaged and ravaged the police station, set it on fire, and 22 policemen lost their lives. In response to this violence, Mahatma Gandhi called off non-cooperation movement, saying, maybe our people are not yet ready for non-violence. Ultimately, he started writing articles in Young India, and in these articles, the government said he is promoting disaffection against the government established by law. And because of his writing, people resorted to violence. Mahatma Gandhi said, and this was something spectacular at that point, when Bal Ganghadhar Tilak was booked for sedition twice, both the cases he said, no, I'm not guilty. I'm not guilty of sedition. I'm not promoting disaffection against the government established by law. But this time, the Mahatma Gandhi is saying, I am guilty of sedition. I'm calling people for non-violence, but it is the government, the measures of the government, which is responsible for people resorting to violence. Don't blame the people. It's the government which is responsible for violence. I am promoting non-violence, but people have no other option but to resort to violence because it is the doing of the British government. Mahatma Gandhi said, non-cooperation with evil is as much important as cooperation with the good. If you're saying I'm guilty of sedition, I'm saying yes, I'm guilty of sedition because it is my duty to promote disaffection against the government which is cruel, which is repressive, which is arrogant. And Mahatma Gandhi said, I'm guilty. Judge Broomfield, who was hearing this case, he said, Mr. Gandhi, you are a different person. I have never tried somebody like you, and maybe in future I'm not going to try somebody like you. But I have to go by the law of the land. You're accepting your guilt. You're saying, yes, you are guilty. And I have to convict you for sedition because you are accepting your guilt. Mahatma Gandhi said, yes, I'm guilty. And I don't want the lightest punishment. I want the highest punishment. And Mahatma Gandhi was sentenced to 6 years in jail. He was booked for sedition, convicted for sedition. But while handing this judgment, Judge Broomfield said, if tomorrow the government would want to release you before, nobody would be more happy than I. But be that as it may, Mahatma Gandhi was booked for sedition. So sedition was used as a law with the primary objective of criminalizing dissent, with the primary objective of not letting nationalist feelings from getting developed. And that is why Tilak was booked under it, Ali brothers were booked under it, Annie Besant was booked under it, Mahatma Gandhi was booked under it. So sedition was primarily used by the British government to control their grip over the people of this country. Then came independence, 1947. And just before independence, Constituent Assembly was called. Constituent Assembly, a body which was responsible for drafting the Constitution. This Constituent Assembly met for the first time on 9th of December 1946. And now this Constituent Assembly has to write the Constitution for the people of this country. That's how the Constitution began, we the people of India. There was a committee on fundamental rights. The head of this committee was Sardar Patel. Sardar Patel said, now that we have fundamental rights chapter, one fundamental right is freedom of speech and expression. But this freedom of speech and expression cannot be absolute. There has to be reasonable restriction on your freedom of speech and expression. One such reasonable restriction should be sedition. Other members of the Constituent Assembly, they criticized Sardar Patel for this. Say, what are you doing? Sedition was misused by the colonial government. Why should people of this country fear their own government? So why should sedition be a reasonable restriction? Because it's not reasonable. Why should sedition be a restriction on your freedom of speech and expression? K.M. Munshi, one of the members of the Constituent Assembly, he moved an amendment, and because of this amendment, sedition was removed as a ground on the basis of which freedom of speech and expression could be restricted. Sedition was not a ground on the basis of which your freedom of speech and expression can be curtailed by the state. But while the debate, the discussion was going on, a beautiful speech was given by Seth Govind Das. Seth Govind Das, he came from a family who were the supporters of the British Raj. His great-grandfather was given the title of Raj Bahadur by the British. His uncle, his father, they were also given the titles by the British Empire. And Seth Govind Das is saying, now I'm very happy. Why? He's saying in the Constituent Assembly that from now onwards, no titles will be given by the state. Article 18, abolition of titles. No titles shall be awarded, shall be conferred by the state. And I'm very happy. And I'm very happy that sedition also is not a ground on the basis of which my freedom of speech and expression should be restricted. He told a story, and this story is very important. He told a story, he said, my great-grandfather, he was given a gold waistband which was inlaid with diamonds, on which it was engraved, a message was engraved in recognition of services during the mutiny of 1857. So in response to the services rendered by the great-grandfather of Mr. Das, a diamond-laced gold waistband was given and presented to his great-grandfather. And Mr. Das is saying, it was a sin. It was sin committed by my great-grandfather. He said that in 1930s, when I was participating in the Satyagraha movement, I gave a speech. I said that this diamond-laced gold waistband, which is given to my great-grandfather for his services for the British Empire, I want to change the wording. I want to mention that now I am apologizing for the sin of my great-grandfather. How am I apologizing? Because I am now working to overthrow the same government which gave this diamond-laced waistband to my great-grandfather. That's how I want to atone for the sins of my family. And for this speech, he was booked under sedition and sent to jail for 2 years. And he said, now I'm very happy that sedition will no longer be used to criminalize dissent in my country. And it is nothing short of remarkable that India's founding fathers ensured that section 124 capital A, it was not part of the Constitution. But then came freedom of speech and expression. Article 19, clause 1, clause A of the Constitution. Constitution said, say whatever you want to say, express whatever you want to express. But this fundamental right is not absolute. There are reasonable restrictions on your freedom of speech and expression. And there are 8 restrictions. Which are these 8 restrictions? Public order, sovereignty and integrity of India, friendly relations with foreign states, the security of the state, incitement to an offense, defamation, contempt of court, decency or morality. There are 8 grounds on the basis of which your freedom of speech and expression can be restricted. Sedition, 124 capital A, is not a ground on the basis of which your freedom of speech and expression can be restricted. Then came Romesh Thapar versus State of Madras. Let's now look at various Supreme Court judgments, how sedition has evolved. If it was not a reasonable restriction in the Constitution, then how is sedition continuing even today? We have to look at Article 13 of the Constitution, specifically Article 13 clause 1. What Article 13 clause 1 says? This is the Constitution of India. This is part 3 of the Constitution, which deals with fundamental rights. A pre-constitutional law, such as Indian Penal Code, if it is in agreement with part 3, these laws will continue. If this pre-constitutional law violates the fundamental rights given by part 3 of the Constitution, these laws cannot continue. Who says this? Article 13 of the Constitution. Now, Romesh Thapar was a communist. And he was a communist, but now he was residing in Madras. And there was a communist weekly which was published from Bombay, which talked about revolution. And now suddenly the Madras government decided to stop the circulation and distribution of this communist weekly in Madras. Romesh Thapar approached the Supreme Court. Romesh Thapar versus State of Madras, 1950. Dear Supreme Court, my freedom of speech and expression has been violated. And how? There is a weekly letter, weekly published from Bombay. It's called Crossroads. The Madras government has decided that you cannot circulate and distribute this weekly in Madras. Why? Please give me an answer. The Supreme Court asked the Madras government, what are you doing? The Madras government said, this Crossroads, this weekly from Bombay, it talks about revolution. And if we start distributing this weekly in Madras, there may be a threat to our public order. That is why we are safeguarding public order. That is why this weekly is banned. Romesh Thapar asked the Supreme Court, dear Supreme Court, please look at Article 19, Clause 2 of the Constitution, where reasonable restrictions on freedom of speech and expression is mentioned. Public order is not a ground on the basis of which freedom of speech and expression can be restricted. The Supreme Court said, yes, public order is not a ground on the basis of which freedom of speech and expression can be restricted. This ban imposed by the Madras government is unconstitutional. And quickly Parliament came together, amended the Constitution. And this was first Constitutional Amendment Act. The year was 1951. And then public order was inserted as one of the reasonable restrictions. Because previously, public order was not mentioned as one of the reasonable restriction. In fact, friendly relations with foreign countries also was not a reasonable restriction mentioned in the original Constitution. 1950, when this Romesh Thapar versus State of Madras judgment was given by the court, then the first Constitutional Amendment Act was enacted, and this first constitutional amendment now added one more ground on the basis of which your freedom of speech and expression can be restricted, and that ground is public order. Pandit Nehru, 1951, he specifically talked about sedition, 124 capital A. He said, so far as this particular section is concerned, for historical reasons as well as practical reasons, this is obnoxious. This is objectionable. It has no place in the society. Practical reasons because let's allow people to criticize the government. If the government is wrong, it's the duty of the citizens to promote disaffection against this government if this government is wrong. And historical reasons because sedition was misused by the colonial empire. It was misused so as to prevent nationalist feeling from getting developed. So for practical reasons, for historical reasons, there has to be no place for section 124 capital A. And Pandit Nehru said, the sooner we get rid of this, better. Punjab High Court, a petition was filed. Punjab High Court said sedition is unconstitutional. Why? Because when we have freedom of speech and expression, which is not absolute, there are reasonable restrictions. But sedition is not one of the reasonable restrictions. When sedition is not one of the reasonable restriction, then Article 13, what does it say? Any pre-constitutional law, if it is in conflict with fundamental rights, this pre-constitutional law is unconstitutional. Sedition, it is not in agreement with freedom of speech and expression. It is not compatible with freedom of speech and expression. It is not a reasonable restriction on freedom of speech and expression. Sedition is unconstitutional. Who said this? Punjab High Court. Very soon, Allahabad High Court said the same thing. Sedition is unconstitutional. Section 124 capital A of Indian Penal Code is unconstitutional. Then came a landmark judgment, brilliant judgment. If you read newspapers today, because of this Vinod Dua judgment, everybody seems to be talking about Kedar Nath judgment of 1962. But the real judgment that people should be talking about is this. Manohar Lohia case 1960. Manohar Lohia, a freedom fighter, he started asking the people, he gave speeches, attended rallies. He asked people not to pay taxes and other liabilities. Basically, he was violating a law. And what is that law? United Provinces Special Powers Act of 1932. This law says that if somebody is instigating people not to pay taxes, not to pay other liabilities, it's a crime. Matter went to the court. Manohar Lohia was booked under this law. He was produced before the court. The court said, why have you arrested this individual? Sir, he has given speeches, and because of his speeches, there may be violation of public order. I said, how? Sir, he is giving speeches and he is asking people not to pay taxes, because of which there will be breakdown of law and order, because of which public order will be threatened. Supreme Court said, no, don't come to us with these hypothetical things. When he will give a speech, there may be violation of public order. There may be threat to public order. People may break law. When people will break the law, then we will discuss. Right now, if he is saying something and immediately it leads to threat of public order, violation of public order, breakdown of public order, then we can book him. Otherwise, he has freedom of speech and expression. Let him say whatever he wants to say. To repeat, Manohar Lohia judgment, a landmark judgment of the Supreme Court in the year 1960. What Supreme Court said? People have, the citizens have the right to criticize the government. People have right to say whatever they want to say. People have right to advocate a cause. If Manohar Lohia is advocating that people should not pay tax, people should not pay liability, it is his fundamental right. But one thing that he should not do, he should not incite people to violence. And this incitement to violence should not be hypothetical, should not be remote, should not be far-fetched. It should be immediate. Because if he is using his freedom of speech and expression and immediately there is violation of public order, immediately public order has been violated, then we can book him. Otherwise, he has freedom of speech and expression. This was a landmark case in the year 1960. And then 2 years later, Kedar Nath versus State of Bihar, 1962. People keep praising this judgment of the Supreme Court. You read the newspapers and you will see Kedar Nath judgment, Kedar Nath judgment. But sedition was given backdoor entry into India. Sedition, although it was part of Indian Penal Code, but Punjab High Court said it's unconstitutional. Allahabad High Court said it's unconstitutional. In Ram Manohar Lohia case, Supreme Court said, say whatever you want to say, advocate whatever you want to advocate, but don't incite people to violence. Otherwise, you can do anything. And for the first time, the Supreme Court has upheld sedition law. Supreme Court for the first time has said, yes, sedition law is constitutional. Parliament did not did this. Parliament did not use sedition as a reasonable restriction. It's the court. It's the Supreme Court which decided that yes, sedition law is constitutional. But what Kedar Nath judgment did, it somewhere prevented the misuse, the abuse, the overuse of sedition. How? Supreme Court in Kedar Nath judgment said, say whatever you want to say. Express whatever you want to express. But don't incite people to violence. Or if your speech has the tendency to incite people to violence, this is sedition and you will be booked for it. Which means previously if you were criticizing the government, which means you were promoting disaffection against the government during the colonial period, you could be booked under sedition. But now in Kedar Nath judgment, although one problem with this judgment was that it upheld the sedition law, but the good part of this judgment was that it has now narrowed down the interpretation of sedition. The Supreme Court said, you want to criticize the government, do it. You want to advocate a cause, do it. You want to propagate something, do it, but don't incite people to violence. If there is no violence, you have not committed sedition. But if your speech has the tendency to incite people to violence, we may book you for sedition. This was Kedar Nath judgment in the year 1962. Then came Balwant Singh versus State of Punjab, 1995. Do you know what Kedar Nath judgment was all about? Kedar Nath was a communist. He gave a speech. He said these CID gundas are everywhere. People of this country fought heroically so that the British goons could be thrown out of this country. But people made a mistake. And what is that mistake? Replacing the British gundas, people started electing the Congress gundas. And now it is our responsibility, it is the job of the people to rectify their mistakes and throw out these Congress gundas. The Supreme Court said, no, you are inciting people to violence, or your speech has the tendency to incite people to violence. This is sedition, and Kedar Nath was booked for sedition. But over a period of time, 1995, Balwant Singh versus State of Punjab. Indira Gandhi was assassinated. Slogans were raised by Balwant Singh and some other individual. Slogans like Raj Karega Khalsa, Khalistan Zindabad. And both were booked for sedition and produced before the court. The court said, no, this is not sedition. Set them free. Why? The court said, slogans, no matter how unpalatable they are not inciting people to violence. So how is it seditious? The court said that it appears that police should not have taken these slogans too seriously. When these slogans were raised, the general public did not notice these slogans. These slogans were raised a couple of times, but largely in general, the people were unaffected and carried on with their normal activities. So casually raising these slogans does not amount to sedition. And Balwant Singh and another man, they were set free. The Supreme Court said slogans, freedom of speech and expression. Unless and until they are inciting people to violence, it is not sedition, you are free. Then came the landmark judgment, Shreya Singhal versus Union of India, 2015. Shreya Singhal was a law graduate, a law student, and she challenged in the Supreme Court the constitutional validity of Section 66 capital A of Information Technology Act 2000. This Section 66A was included into the IT Act in the year 2008. What was this act? This section 66A said, if you're using an electronic device, for example, a laptop, for example, a palm top, a smartphone, and through which you transmit messages which cause annoyance to the public, this is a crime. And for that, we will book you under section 66 capital A. The Supremo of Shiv Sena, a political party from Maharashtra, Bal Thackeray, he died. And then the supporters of the Shiv Sena called for a bandh in Maharashtra. One lady, Shaheen Darda, she wrote on her Facebook, what is the need to call for a bandh when Shiv Sena, when Bal Thackeray has died? One of her friends liked this Facebook status. Both were booked under section 66 capital A because they used a computer device to transmit a message which caused annoyance to the members of the Shiv Sena. They were booked. Shreya Singhal, a law student, approached the court and asked the Supreme Court, dear Supreme Court, section 66 capital A is violative of my freedom of speech and expression. Truth. How can it be inconvenient? Or even if truth is inconvenient, inconvenience is not a ground on the basis of which your freedom of speech and expression can be restricted. Your freedom of speech and expression can be restricted on the grounds of public order, incitement to an offense, contempt of court, morality, decency, 8 grounds. Where is this ground mentioned? Inconvenience. That you say something, if it causes inconvenience to me, you are guilty of committing a crime. Where is it mentioned? In the Constitution. Justice Rohinton Fali Nariman wrote this judgment and he said this section 66A is unconstitutional. It violates freedom of speech and expression. But perhaps for the first time, the Supreme Court is now defining what is a speech. The Supreme Court said there is a distinction between advocacy and incitement. Rohinton Fali Nariman wrote this judgment. And what is this difference between advocacy and incitement? Let's say, for example, I am advocating a revolution. Revolution, something which was advocated by Harold Lasky in United Kingdom. I am advocating a revolution. I am advocating a cause, revolution. Over a period of time, 2 years later, 3 years later, somebody would be fascinated by my speech and he would resort to violence. This is advocation. I am advocating a cause. Then there is incitement. Incitement is immediate. Immediately I am telling people, please come out of your houses, attack your neighbor, kill them. And when I am saying this, immediately you come out of your houses, you start killing your neighbors. What is this? This is immediate reaction to my speech. I am inciting people to violence. And this incitement is immediate. Supreme Court said, advocate whatever you want to advocate. Even if it's a revolution, advocate it. But don't incite people to violence. And this incitement to violence has to be immediate, imminently, immediately. There has to be a reaction to your speech. If the reaction is immediate, you will be booked. Otherwise, you have absolute freedom of speech and expression. Say whatever you want to say, express whatever you want to express, advocate whatever you want to advocate, but don't incite people to violence. And this incitement has to be immediate. It can't be far-fetched. It can't be hypothetical. That maybe because of your speech, there will be incitement to an offense. People may be incited to violence. No, it has to be immediate. There has to be immediate link to incitement in your freedom of speech and expression. This was 2015, Shreya Singhal versus Union of India. But now, should sedition law continue? There have been instances where sedition law has been misused. But does that mean just because a law is misused, we don't need that law? Just because a law is liable to be misused or can be misused or has been misused, does that mean this misuse of a law should be the reason why we don't need that law? No. There is a strong reason why sedition should continue. And what is that reason? Reason number one. What about international activities where terrorists, secessionists, Naxalites, Maoists, they want to overthrow the government established by law? Should they not be booked for sedition? For trying to promote disaffection against the government established by law? For this very reason, since we are facing threats of terrorism, secessionism, Naxalism, Maoism, sedition law should continue. Reason number one. Reason number two, hypothetical situation. 2014, a political party won the election. 2019, the same political party won the election. 2024, the same political party is going to win the election. For example, the opposition is short of ideas. This political party won the election in 2014, 2019, now 2024 as well. We are not able to connect with the masses. We are not able to overthrow this government. We are not able to overthrow this government through democratic means. Can you overthrow this government? Yes. How? Through democratic means. Go back to the people of this country, ask for votes, and the people trust you. They will elect you to power. They will vote this government out. But if through democratic means you are not able to convince the masses, you are not able to capture political power, you are not able to defeat this government, this political party, should you then resort to violent means? Should you then resort to promoting disaffection against this government, calling the people, please come to Delhi and let's overthrow this government? This is why we need sedition law. Because if you want to overthrow this government, you have democratic means of overthrowing this government. But if you're asking people, you're inciting people to violence so that this government can be overthrown, this is why we need sedition law. That's point number two. Point number three, contempt of court is one of the restrictions on your freedom of speech and expression. Can't say anything about the judges or the judgments of the court. You can criticize, but not beyond criticism. If contempt of court can be one of the grounds on the basis of which you can be booked, then contempt of the government should also attract punishment. That's reason number three why sedition law should continue. Reason number four, there are various districts, many places in India where Naxalite movement is at its peak, where Maoist movement is at its peak. There are areas which they call liberated areas where the state is absent, where the government of India is absent, where the state governments are absent. They are liberated lands where Maoists, they rule the roost. And it is the objective of the Maoists and the Naxalites to overthrow the government in Delhi. For this very reason, we need sedition law. And just because this law has been used, overused, misused, abused, that doesn't mean misuse of a law is a ground on the basis of which the law should be deleted, scrapped. For these very reasons, sedition law, section 124 capital A of Indian Penal Code should continue. But now, we also see that there is a misuse. One girl, a 19-year-old Amulya, she raised a slogan, Pakistan Zindabad. And for that, she was booked for sedition. Later on, when people started searching her Facebook profile, she said, any government which works for the people, long live that government. Zindabad that government. So she said, Bangladesh Zindabad, Pakistan Zindabad, Sri Lanka Zindabad, Maldives Zindabad. Any government which works for the people, Zindabad, long live. But she was booked for sedition. By that logic, our former Prime Minister who said Hindi Chini bye bye should also be posthumously booked for sedition. Why should saying that one country Zindabad or long live one country, is that a ground for sedition? Sedition means promoting disaffection against the government established by law. Here Amulya, whether you agree with her slogan or disagree, she's saying Pakistan Zindabad. How is it promoting disaffection against the government established by law? This girl was booked for sedition. She spent some time in jail as well. Some say misuse. That is why I have used the term alleged misuse of sedition. Number two, Pathalgadi movement, Jharkhand. In Jharkhand, Adivasis, they are aware of their rights. They are aware of Schedule 5 of the Constitution. In Schedule 5 of the Constitution is a constitutional guarantee for their tribal rights, for the protection of their land rights. And these tribals, they started fearing that the government is trying to snatch their land. They started a movement. They took these stones, monolith stones, and they started engraving the guarantees that are mentioned in Schedule 5 of the Constitution. The government said, this is sedition. 10,000 people in the villages, part of this Fatehgarh movement, they were booked for sedition. Why? Writing something which is mentioned in the Constitution. The safeguards mentioned in Schedule 5 of the Constitution, engraving these safeguards on stones. How is this sedition? Misuse. A 9-year-old participant, I'm just giving you these examples so that you become aware that there have been instances where this law has been misused. One example, a 9-year-old was participating in a play in a school in Karnataka. And then in this play, one of the scenes were that somebody who looks like, who's a look-alike of the Prime Minister, was slapped by a chappal. Booked for sedition. Who? The mother of this 9-year-old child as well as the school principal. Why? Because you are promoting disaffection against the government established by law, the Prime Minister. Even if this scene is correct, horrible scene, mischievous scene, tasteless scene, but does that amount to sedition? How can we say that mere criticism or horrible speeches against the Prime Minister is promoting disaffection against the government? That's why some people say that this law has been misused. And if you look at the data, National Crime Records Bureau, this data tells us that in the year 2019, the conviction rate was 3.3%. What is this conviction rate? Those who have been arrested, booked for sedition, only 3.3% of these people who have been booked for sedition were in reality convicted. Others were set free, which basically means this law, although in majority of the cases, all those who have been booked for sedition, they are later set free. But since they are arrested, since they spend time in the jail, this process itself becomes punishment. And when the process itself becomes punishment, that is why people say scrap Section 124 capital A of Indian Penal Code, the sedition law. That's again. Now let's look at what writer, lawyer Abhinav Chandrachud said, and he wrote in his beautiful book. He said sedition is like a self-inflicted wound on us. How? He said, to be fair to the British, during the British rule, sedition was a non-cognizable offense, which meant that if you are guilty or if you're accused of sedition, you will not be immediately arrested. Permission of the judge should be taken. After that, the investigation will take place. The warrant can be issued and you can be arrested. So sedition during the colonial period was a non-cognizable offense. The year was 1973. The Prime Minister then was Srimati Indira Gandhi, when sedition was made as a cognizable offense. So now at the drop of the hat, if you accuse me of sedition, I will be arrested. And it's a non-bailable offense as well. So sedition is like a self-inflicted wound on us. The cases of misuse that we see in independent India, we didn't even saw this misuse or this gross misuse even during the pre-independent India or during the colonial period. That's what some activists say. When we look at free speech, what is this free speech? Does that mean free speech? And this is something very important, very interesting, and something very, very thought-provoking. What is free speech? Should I be only allowed to say flavory speeches? Or does free speech also give me the right to say something which is eccentric, which is something contentious, which is something provocative? Let's be provocative, but have the reason to be so. Should I only have the right of free speech wherein I say something which is inoffensive? I'm all in praise for you. Or should I also have the right to criticize you, to say something offensive, to say something which is eccentric, to say something which is unwelcome, to say something which is provocative? It is this free speech that should be provided to every single citizen. That's how we can become a mature democracy. Freedom only to speak inoffensively is not the free speech worth having. And that's what former President of United States, a statesman, a philosopher, James Madison said. He said, this is something very interesting. Sedition is like the government is censuring the people. Sedition is government is censuring the people. That means government is censoring the people. Government has the censorial power over the people. But who is sovereign? Not the government. Who is sovereign? Not even the legislature. Is Indian Parliament sovereign? No, it's not sovereign. Sovereignty lies with the people. So instead of government censoring the people, it should be the other way around. People should have the censorial power over the government. That's what James Madison said. So some people say instead of this section, wherein we say promoting disaffection against the government established by law, it should be that if the government is promoting disaffection against the people, particular section of the people, particular caste group, particular religious group, particular group with different sexual orientation, if the government is promoting disaffection against that group, the government should be booked for sedition, because sovereignty lies with the people. Sovereignty does not lie with the government. Sovereignty does not lie even with the legislature. The people are sovereign. And that's how preamble begins with, we the people of India. Then something else, if you look at the global picture, Australia, New Zealand, United States, they have all junked the sedition law. Even the colonial masters, Britain, 2009, sedition was removed. Law Commission of India in its report, not report, it was a consultation report, it basically said that sedition should be either repealed or we should have a rethink on sedition. Why? Because dissent, that's what Voltaire said. I disagree with what you say, but I will defend till death your right to say it. Disagreement is health. Dissent is part of democracy, bedrock of democracy. Dissent and criticism, they are the essential ingredients of a robust public debate. And this is part and parcel and integral part of a vibrant democracy. And dissent should not be criminalized. And that is why sedition should be repealed or we should have a rethink on sedition. That's what Law Commission of India said. But then the argument that I told you, that there are secessionist activities, there are terrorist activities, international activities going on, should we allow that? Should we allow these terrorists, secessionists to wage war against the country? No. We don't need sedition for that. We have a different law for this, and that law is UAPA, Unlawful Activities Prevention Act. If you are promoting something against the nation, international activity, unlawful activity, terrorism for example, you will be booked under an even stricter law which is UAPA, Unlawful Activities Prevention Act. So if we have UAPA, there is no need for sedition. Because to curb the secessionist activities, terrorist activities, we have a much better law to deal with that, and that is UAPA. Although some people disagree with UAPA as well, criticize UAPA as well, but here let's not get too deep into the UAPA and the critical part of it. Let's look at the relationship between UAPA and sedition. If sedition law is scrapped, that doesn't mean all the international activities will continue, because UAPA is still in place, would continue to remain in place. Kedar Nath judgment. Some people say it's a landmark judgment, but is it? Let's try and critically analyze the Kedar Nath judgment as well. One problem with Kedar Nath judgment is that it upheld sedition law. It said sedition law is constitutional, right? But one good part of Kedar Nath judgment was that it narrowed down the scope of sedition. Any criticism of the government is not sedition. You say whatever you want to say, you express whatever you want to express, you advocate whatever you want to advocate, but don't incite people to violence. But Kedar Nath judgment said something else as well. Tendency of incitement to an offense. If you are inciting people to violence, or if your speech has the tendency to incite people to violence, you will be booked for sedition. That is why some people say it is not the Kedar Nath judgment, it is the Ram Manohar Lohia judgment which should be implemented today. Because when Ram Manohar Lohia judgment said, even if there is violence, but if that violence is far-fetched, is much later, not immediate, your freedom of speech and expression will be protected. So Ram Manohar Lohia is a better judgment than Kedar Nath judgment. And Ram Manohar judgment was in bits and pieces addressed by the Supreme Court in Vinod Dua Case, but not much emphasis was given on the Ram Manohar Lohia judgment, but more emphasis was given on the Kedar Nath judgment. Protection for media. Vinod Dua, he asked the Supreme Court that please quash the FIR against me, the sedition FIR against me. And he also had another part of his plea. Another part was there, which was part of the petition filed by Vinod Dua. He said, if there is a journalist, he needs more protection. If there is a journalist who has been a journalist for 10 years, the police should not arrest this journalist on any allegation, unless and until a committee gives a clarity, gives the permission. And what is that committee? The committee should consist of the Chief Justice of that state High Court, the leader of opposition in the Legislative Assembly, and the Home Minister of that state. I said, why? Sir, the journalists, we need to expose the government as well. I said, why? The government is not handling environment properly. Should we not educate the people that this government is wrong in its environmental direction? But the state will say, the government will say, you are promoting disaffection against us. That's why you can be booked under sedition. Media, journalists particularly, they need more protection because they are more vulnerable to sedition. That's how Rajdeep Sardesai and others, they were also charged with sedition some time ago. But the point is that Vinod Dua basically said that journalists should have more protection. If somebody is filing a sedition case against a journalist who has been a journalist for 10 years, he should not be arrested. Unless and until a committee consisting of these three individuals should decide whether this is a sufficient ground for sedition or not. The Supreme Court said no, this cannot happen. Why? Because we are then encroaching into the domain of the legislature. To modify a law, to change a law, that's the job of the parliament. That's the job of the legislature. But since this is not our domain, we are not getting into it, we will tell you that you have the protection based on Kedar Nath judgment. And what is that protection? Say whatever you want to say, express whatever you want to express, but don't incite people to violence. And your speech should also not have tendency to incite people to violence. Otherwise, you are free to practice your profession, to practice your freedom of speech and expression. But then why should media get more protection? I'll just give one example. And the example is from Uzbekistan. The year was 2005. And a journalist, a few years later, he was booked under sedition. Why? Because he gave international media some footage, some evidence of the Andijan massacre. Andijan massacre of 2005, scores and scores of protesters were killed by the Uzbekistan government. One journalist, he gave international media the evidence of these killings, of this massacre, and this individual was booked for sedition. That is why journalists would need more protection. More protection because if they want to expose the government, because the government is committing some wrongs against its own people, the journalists have the responsibility of exposing the government. And if the journalists don't have more protection, then they will not be in a position to do their job effectively without any threat, without any fear. And that is why journalists, they deserve more protection by the courts. And lastly, there is one argument that sedition law should continue. There is another argument that sedition law should be scrapped. It should not continue the way it is. Some people say it should not also be scrapped. Then what is the way forward? The way forward is make it a non-cognizable offense. Unless and until the magistrate gives a permission, you can't arrest a particular individual who has been accused of sedition. Because I've told you, in sedition cases, there is the conviction rate of 3.3%, which basically means majority of the people are set free. They are not convicted for sedition. But the process becomes a punishment. And for that, the way forward is make sedition a bailable offense, make it a non-cognizable offense, And the investigation in all these sedition cases should be conducted by an individual, by a police officer of the rank of the Superintendent of Police. So what did we discuss today? We looked at what is sedition? What is the meaning of Section 124 capital A of the Indian Penal Code? Then we looked at what is the origin of sedition law in India. We looked at the two blatant cases of misuse of sedition law in pre-independent India, the case of Lokmanya Tilak and the case of Mahatma Gandhi. Then we looked at some of the Constituent Assembly debates surrounding sedition. We looked at various Supreme Court judgments on this case. We looked at the judgments of Punjab High Court, the Allahabad High Court, Romesh Thapar versus State of Madras. Then we looked at Kedar Nath versus State of Bihar, 1962. Then we looked at the Balwant Singh case of 1995. Then we looked at the Shreya Singhal case of 2015. And we also looked at the arguments in favor of the sedition law. We looked at the arguments against sedition law, and we also looked at the way forward. But we also laid particular emphasis on journalists, on media, and why media should get more protection, because it's the job of the media to fearlessly expose the government if the government is anti-people. That is it from this segment of Explained. Thank you for being with us. Have a great time. And if you're liking these initiatives, if you like this lecture, why don't you press the like button and subscribe to our channel if you haven't yet. See you next Friday, 8 o'clock. Till then, have a great time. Bye-bye.